Welcome to this recorded presentation of Child Protective Services removal process. My name is Mary Savage, and I work for the Kentucky Coalition Against Domestic Violence. We know that many domestic violence survivors are either at risk for losing their children because of allegations of abuse or neglect, or they've already experienced it and are working to get their kids back. Dealing with Child Protective Services and going to court can be a confusing and intimidating experience. We believe that it's important for parents to understand how this can happen and what happens after a child is removed, in order for there to be positive outcomes for survivors and their children. The goals for this training are to go through the process of how children can be removed from their parents and what the court process looks like after removal. We also want to discuss your rights as a parent, share some helpful resources, and identify some points of where you can advocate for yourself and your children in this process. A child may be removed from their parents' care when it is suspected that the child is either dependent, neglected, or abused. This can cover a variety of situations, but most broadly it means that the adult with custody of the child is not properly caring for or able to care for the child, or is not ensuring that the child's needs are met, or the parent has abused the child or allowed another person to abuse the child. For survivors of domestic violence, dependency, neglect, and abuse can also mean that the child has been exposed to violence in their home. While domestic violence is never the fault of the survivor, failing to protect a child from the risk of abuse or from witnessing abuse in the home may be considered grounds for removal and the eventual termination of parental rights. Therefore, it's important for survivors to understand the child removal process if a disclosure of domestic violence results in a Child Protective Services investigation. There are two ways that a child can be removed from a home. The first is emergency removal, and the second is removal through filing a juvenile dependency, neglect, or abuse petition. In the case of emergency removal, the child is immediately removed from the parent and placed in some form of out-of-home care. This happens when there's a belief that a child is in immediate danger of death, serious physical injury, or sexual abuse, and that the parent is unwilling or unable to protect the child. The parent does not have to be the cause of the immediate danger, but only has to be believed to be unwilling or unable to protect the child. Only law enforcement and doctors or hospital administrators can begin the emergency removal process. Law enforcement officers can physically remove a child from their home when they believe that the child is at risk of immediate death, serious physical injury, or sexual abuse, and that the parent cannot or will not protect the child adequately. If law enforcement removes a child, they must request an emergency custody order within 12 hours of removal. Law enforcement will seek assistance from DCBS, the Department of Community-Based Services, also sometimes called CPS or Child Protective Services, in order to find an emergency placement for the child. This may be with a relative or in foster care. If a doctor or hospital administrator suspects that a child under their immediate care or hospitalization is in immediate threat of harm because of dependency, neglect, or abuse, and that the parents cannot or will not protect the child adequately, they can hold the child for up to 72 hours. During that time, they must request an emergency custody order. They will probably also request assistance from Child Protective Services or law enforcement. Whether emergency removal has occurred because of law enforcement or a doctor or hospital, after the child is removed, they must file for an emergency custody order. In filing for an emergency custody order, a law enforcement officer, doctor, or hospital administrator will fill out a juvenile dependency, neglect, or abuse petition. In deciding whether to grant an emergency custody order, a judge will review this petition and sworn statements that have been provided. Based only on reviewing these allegations, the judge will determine if the child is at risk of serious harm occurring if the child was to be left in the care of the parent. If the judge determines that there is a risk of harm to the child, the judge can order removal of the child for up to 72 hours. During this review, the judge may also set a temporary removal hearing, which we'll talk about more in a minute, or they could dismiss the petition and the child would have to be returned to the parents. In order for the judge to grant the emergency custody order, the judge must find that one or more of the following is true. Either the child is in immediate danger of death, serious physical injury, or sexual abuse, or the parent has repeatedly inflicted or allowed to be inflicted upon the child physical or emotional injury, or that the child is in immediate danger due to a parent's failure or refusal to provide for the safety or needs of the child. If the judge grants an emergency custody order, DCBS will assume custody of the child and place the child in out-of-home care with a relative, fictive kin, or foster family. Fictive kin just means a person not legally related to the child, but who has an established close relationship with the child. If the judge does not grant the emergency custody order, the child will be returned to the parent's care or not removed. But the judge can still set a temporary removal hearing and may later consider removing the child. The other route to removal of a child is through the filing of a petition with the juvenile court. Any concerned adult who has reason to believe that a child is in immediate danger can attempt to file a juvenile dependency, neglect, or abuse petition through the county attorney's office. Often, the person who files the petition is a Child Protective Services worker who's been investigating an allegation of dependency, neglect, or abuse. Other times, the person might be a relative of the child, such as a grandparent. In that petition, the individual will state the grounds from which they believe the child is in immediate danger of death, serious physical injury, or sexual abuse, or physical or emotional injury, and that the parent is unable or unwilling to protect the child. They are sworn to the affidavit, and the petition is reviewed by a judge. If the judge feels the stated grounds indicate an immediate danger, they may sign an emergency custody order, and the child will be removed immediately and placed with a relative, fictive kin, or with a foster family. Sometimes the judge will not feel that an emergency custody order is necessary right at that time. That is, the judge doesn't feel like there's an emergency and the child needs to be removed right away. But the judge may go ahead and grant the petition, leaving the child with the parent, but setting the matter for a court hearing, which must occur in juvenile court within 10 days. The parent should be served with a copy of the petition so they will know what the allegations are, and with a summons telling them when and where to be in court. However, the law allows this notice to be left with the parent's closest known adult relative, or it may be mailed to the parent's last known mailing address. So in fact, it's quite possible a parent may not receive notice of the hearing until after it has happened. If you become aware that CPS is investigating you for possible child abuse or neglect, or that a relative may be trying to file a petition against you to get an emergency custody order, you should keep in contact with your local DCBS office. The worker you might have spoken to is the best person to keep in contact with. You could also contact the circuit clerk's office or the county attorney's office to see if the judge has set the matter for a hearing. Even if you do not get served with notice, if you know court is going to happen, you should try as best you can to show up. Things can move very quickly, and it may be they sent the notice to an address you don't live at anymore, or left it with someone who doesn't tell you about it. The judge can hold the temporary removal hearing even if you're not present. The first court hearing, where the parents will appear in front of the judge, is called a temporary removal hearing, or TRH. If a child has been removed from their home, either by the police or a doctor or hospital, or if a judge has issued an emergency custody order, the first court hearing must take place within 72 hours. This is 3 days, 3 business days, so it does not include weekends or court holidays. Keep this in mind. If your child has been removed and you don't hear anything about having to be in court, contact the circuit clerk's office right away. Again, things are going to happen quickly. If the child has not yet been removed, the temporary removal hearing must occur within 10 days of the petition being filed. The county attorney representing DCBS has to prove to the court that there is a reasonable ground to believe the child will be dependent, neglected, or abused if returned to or left in the custody of the parent. At this point, the county attorney does not have to prove who committed the dependency, neglect, or abuse, and hearsay evidence is allowed, such as the case investigator testifying as to what was told to them by witnesses or the child. This is not a final hearing. The judge just has to find probable cause to give temporary custody of the child to the state. Under Kentucky law, parents are not entitled to a court-appointed attorney at this hearing. If the parents can afford to pay for a private attorney, they can, of course, have representation at this hearing. But for most of the domestic violence survivors we work with, this will not be possible. Although a parent is not entitled to a court-appointed attorney at this first hearing, many judges across the state will appoint one for you if you ask. You should always ask the court to appoint an attorney for you. You should fill out an affidavit of indigency to show that you cannot afford to hire an attorney. You can do this before the hearing. Ask at the clerk's office for the form. Tell them you want the form to ask the judge to appoint an attorney for you. There's a statewide custody and visitation legal advice hotline that you can call if you have to go to court. That number is 1-844-673-3470. An attorney will be able to answer your questions and give you some general advice about what you might want to say or do in court. They can also go over your rights with you. We highly encourage you to call this hotline prior to going to court the first time, if you have the opportunity to do so. There are several different outcomes that might happen at this first hearing. If the judge does not find that the child is in danger and that the parents can be protective, the petition may be dismissed, and the child will either stay with or be returned to the parent. If the child was removed from their home, but somehow the temporary removal hearing is not held within 72 hours, the emergency custody order will expire, and the child will be returned to the parent. That's pretty unusual. This is why this first court hearing happens so quickly. Sometimes the DCBS worker and the county attorney will ask the parent if they are willing to stipulate that there is cause to believe that the child is dependent, neglected, or abused. What is a stipulation? To stipulate to something means you agree to it or agree with it. So a stipulation at the temporary removal hearing stage means you are agreeing that there is probable cause to believe that your child is dependent, neglected, or abused. Parents should think very carefully before agreeing to stipulate to anything. Most parents don't want to stipulate to abuse. It sounds bad. So sometimes, especially in cases where the parent is a victim of domestic violence, who is being portrayed as non-protective simply because they are being abused by a partner, DCBS will offer to let them stipulate to dependency. It may be portrayed as something less bad, because it implies the parent is not at fault for what's going on in the home. But the bottom line is, once the parent stipulates to anything, then the state will have temporary custody of the child. In most cases, the parent will still have to work a case plan, either to avoid removal or to get the child back, if they've already been removed. A stipulation is an admission or agreement that the child is in need of protective services. Unfortunately, without legal representation, parents have no way of knowing if stipulation is the best choice or not. Once stipulation is held out as a way for the parent to get the child back more quickly, premised on the parent being able to begin working the case plan earlier, that sad reality is that once having stipulated, the parent may find it difficult to successfully complete that case plan. The child may remain in an out-of-home placement for months. In some counties, a parent may be appointed an attorney to represent them at the temporary removal hearing. In most counties in Kentucky, however, this will not be the case because the law doesn't require it. It can be a very confusing moment for the parent, and again, there may be pressure to stipulate to something. But once the parent stipulates or agrees, they will find it much harder to contest the allegations of dependency, neglect, or abuse later on. If the judge does not dismiss the petition and the parent does not stipulate to anything, then there will be a hearing. At the conclusion of the hearing, if the court finds reasonable grounds to believe that the child will be dependent, neglected, or abused, if left with or returned to the parent, then the judge will enter a temporary custody order. It is only at this point that the law requires that a parent be appointed a lawyer to represent them. If the judge enters an order giving temporary custody of the child to the cabinet, the child may be placed with a relative, fictive kin, a foster family, or may even be placed with the parent, but only if the judge feels the parent with appropriate services can keep the child safe. There will be a case planning conference within 10 days of the hearing, where the parent and DCBS will come up with a plan to either keep the child safe at home or to reunify the child with the parent once that can be accomplished safely. After the temporary removal hearing, if the child is held in state custody, an adjudicatory hearing will be scheduled. This should be held within 45 days of the first hearing, but it may be continued one or more times if the judge feels that is necessary. The parent may at any time file a petition for immediate entitlement with the court directly above the juvenile court. This petition says there's no evidence to support removal of the child, and the parent wants the child back. The parent has to show clearly that there are absolutely no grounds for removal of the child. These petitions are rare and most often unsuccessful. The parent would almost certainly have to hire their own attorney to do this for them. But it is an option where there are simply no grounds whatsoever for the state to keep the child in state custody. If, after the temporary removal hearing, the parent does not agree that the child is dependent, neglected, or abused, there will be an adjudicatory hearing. This should take place within 45 days, although it may be later if the court decides it's necessary to continue the case. Sometimes, instead of a hearing, there's an informal adjustment where everyone agrees on what's going to be done and there's no need for a hearing. This is pretty common. However, parents do have the right to a full-blown evidentiary hearing. The parents have the right to counsel and to testify and present evidence. The county attorney will be presenting evidence of dependency, neglect, or abuse. There will also be a GAL, or guardian ad litem, who is an attorney appointed to represent the child. A final disposition is supposed to be made at the adjudicatory hearing. This is basically where the court makes a finding, yes or no, if the initial allegation of dependency, neglect, or abuse has been proven up by the county attorney. If yes, then DCBS will present a case permanency plan to the court, outlining how services will be provided to the family so that the child can be reunified with their parent. An attorney will be appointed for you at or after the temporary removal hearing. If one is not offered to you, make sure to ask the judge to appoint one for you. This will be the attorney who represents you at the adjudicatory hearing. It's very important that you be in contact with your attorney so they can prepare. You can discuss with your attorney if you want to call witnesses or present evidence at the hearing. Your attorney will also be able to cross-examine the witnesses that the state calls to testify. You have the right to make the state prove the allegations of dependency, neglect, or abuse. You have the right to have a victim's advocate be in court with you if one is available. You can check with the local domestic violence program that you're working with to see if an advocate is available and can go with you. If you are not satisfied with the outcome of the hearing, you have the right to appeal the judge's order. However, you'll need an attorney to do this for you. You should discuss this with the attorney who has been appointed to represent you. What are the possible outcomes of the adjudicatory hearing? It's possible that the judge will determine that there's no risk of dependency, neglect, or abuse for the child at this time. The child will be returned to the parents, and the case will be closed. If the court determines that the child is dependent, neglected, or abused, temporary custody will probably remain with the state. However, this doesn't always mean that the child will remain in out-of-home care. The judge must consider alternatives to removal, such as providing services to the family by the cabinet or another agency that would be enough to keep the child in the home and safe. This may be enough to allow the child to remain with or be returned to the parent. If the child's not able to stay in or be returned to their home, the judge can order out-of-home placement with a relative, fictive kin, or foster care. This can only be ordered if reasonable efforts have been made to prevent removal and that leaving the child in the home would be contrary to the child's welfare. If the state keeps custody of the child, a case plan will be developed with the goal being family reunification. If out-of-home placement is ordered, then the parent should have some form of visitation ordered as well. Unfortunately, parents often do not get very much visitation with their children. It may be very limited, and they may have to go to a visitation center or the local DCBS office for the visitation. Transportation or work schedules can result in a parent missing visits. But it's very, very important for you to make sure you go to scheduled visits. DCBS will be monitoring this, and missed visits are usually seen as a significant negative mark against the parent. If you are experiencing recurrent issues that prevent you from going to see your child, it's very important that you discuss this with your caseworker and try to find a solution. You can also try talking to your advocate to see if they can help you or link you to other community resources to make sure you get to see your child. You may also need to talk to your attorney to revise the visitation schedule. A case permanency plan will be filed by DCBS with the court within 30 days of the first order giving temporary custody of the child to the state. The caseworker, the parent, and other interested parties will work together to come up with the case plan that the parent will be required to complete to avoid removal or to get the child back. At this time, a permanency goal is also set. The case permanency plan covers why the child is in custody, the current placement and why it's appropriate, what tasks the parent must complete, what services will be provided to the parent and the child in order to reunify the family, the overall time frame for the plan, and what goals the parents have completed so far. However, the cabinet can change the plan or the child's placement as needed. This is where a lot of parent survivors get caught in a trap, where the case plan changes a lot and makes it really hard to successfully complete it. We'll talk a little bit more about what parents can do about that in just a few moments. Once a case permanency plan is in place, there will be periodic case reviews. DCBS has to give a recommendation to the court after the child has been out of the home for a total of 6 months. At this point, DCBS will recommend reunification or termination of parental rights. There must be a similar case review and recommendation made every 3 months thereafter. All this time, the parent may be trying to finish up that case plan. At the case review, the court will consider everything that has been going on and how likely it is that the parents will successfully complete the case plan. They will also be looking at what next if reunification does not seem likely. Working a case plan is never easy. Along the way, you may encounter problems which, if not resolved, may make it difficult or impossible for you to successfully complete your plan. This will delay or prevent you from getting your child back. When problems arise, don't let them go unaddressed. Try to the best of your ability to get them resolved. Each problem may present unique challenges, but generally the first person who can help you will be your DCBS worker. If you can't resolve the issue with your caseworker, ask to speak to their supervisor. It may also be helpful to talk to your attorney about the difficulties you are experiencing. That attorney is not only there to be at court hearings with you, but they should also be willing to advocate for you when needed with DCBS. It's important for your attorney to know when and why you're having trouble making progress towards completing your plan. Another good resource is your domestic violence advocate. They may be able to help you brainstorm possible solutions, such as helping you access transportation or childcare, so you can keep appointments and attend classes. They may even be able to go with you to talk to your caseworker or try to work on a solution and help you ask for assistance. If you need to file a complaint, they may be able to help you fill out the form or add useful information so the cabinet will have a clear picture of what's going on. If the problem you are having cannot be resolved at the local office level, you have the right to talk to the regional office representative. Your caseworker should provide you with that person's name and phone number if you ask for it. Finally, you may decide to file a service complaint with the cabinet. You may file a complaint at any time, but usually it will make sense for you to try these other options first before you file a written complaint. Child Protective Services is part of the Cabinet for Health and Family Services. Because they are a state agency providing services to Kentucky's citizens, you have the right to file a written service complaint if you are denied services or if you are dissatisfied with the services you've been provided, or if you feel like you've been treated unfairly or discriminated against. You should ask your DCBS worker for Service Appeal Form DPP 154 and mail it to the address given on the form. Again, you can ask your attorney or your advocate to help you write out the complaint, or possibly provide additional written information. Remember, it's important to keep all your paperwork and document what has been going on, so you will know dates and the people who were present when things occurred. You will be contacted by a cabinet representative to discuss your complaint. This may result in it being resolved quickly and informally, or the cabinet may decide to investigate your complaint and even possibly to hold a hearing. If you need a form or have questions about filing a service complaint with the cabinet, you can call the Office of the Ombudsman at 800-372-2973. Remember, if you disagree with the judge's orders, you'll have to address that by filing an appeal with the court. You should discuss that possibility with your attorney. Removal of children can quite easily lead to termination of parental rights if the parent cannot overcome whatever barriers there are to successfully completing their case plan. Issues such as lack of financial resources, lack of transportation, lack of employment or housing, and even high turnover and high caseloads for DCBS workers can create huge problems for parents. Along with many other grounds for termination, if a child has been removed more than 2 times in a 24-month period, or if a child has been in foster care a total of 15 cumulative months in the prior 48 months, those can lead to termination of parental rights. Simply failing to make sufficient progress towards completing a case plan can be a separate grounds for finding the child is abused or neglected. Hopefully, though, parents will be successful and the family will achieve reunification. A little less than 40% of cases will close with a successful outcome for parents and children. That concludes our presentation on the child removal process in Kentucky. We hope that you now have a better understanding of how children can be removed from their parents and what will happen once a child is removed or when removal may be threatened. We hope that understanding the process of child removal will empower survivors to advocate more effectively for themselves and their children.